Where law ends, tyranny begins. This is Unmasking Justice series, aired on Silent Screams Loud Strength. Good day and welcome. I want to begin with clarity, and I want to begin without dilution. I have been reminded that honesty carries consequences. You are permitted to speak until what you say begins to carry weight. And I say this now without hesitation. I will not step back. I provoke no one. I simply stand where conscience and sacred duty demand, in truth, in spirit, and in light. This is not defiance. This is not performance. This is my position. And I will not be silenced. Let's define something properly, because words matter. Tyranny is not always loud, it is not always visible, and it is not always declared. Tyranny in a legal modern system emerges when power operates without restraint, when process replaces justice, and when those who should be protected find themselves exposed instead. Tyranny is what happens when the law exists but is not properly applied. Tyranny is what happens when systems designed to protect the vulnerable fail to recognize vulnerability. Tyranny is what happens when fairness is reduced to form and substance is ignored. And I say this clearly: where the law ends, tyranny begins. This episode is not a personal complaint. It is a structured account grounded in law, rights, and system observations, because the family justice system in England and Wales is not only optional in its duties, it is bound by legal instruments, including the Human Rights Act 1998, which gives effect to fundamental rights. Article 6 guarantees the right to a fair hearing. Article 8 protects home and family life. Article 14 prohibits discrimination. Article 1 of Protocol 1 protects the peaceful enjoyment of possessions. These are not symbolic rights. They are rights you are entitled to. They are enforceable obligations, and they exist for a reason, and they should always be exercised in court, because when people enter the family court, they are not there at their strongest. They are at their most vulnerable state. They are navigating the breakdown of relationships, the reorganization of finances, the protection of children, and often the aftermath of domestic abuse, coercive control. And the law recognizes this. This is why the family procedure rules include Part 3A and Practice Direction 3AA to ensure that vulnerability is identified and that participation is supported in the whole process. Because participation is not simply about being present, it is about being able to engage effectively during a hearing, to understand, to respond, to be heard. But what happens when these safeguards are not properly in operation during a hearing? what happens when vulnerability is acknowledged in theory but not accommodated in principle or in practice? What happens when participation becomes impaired not because of lack of willingness but because of trauma, pressure, and imbalance? Then we must ask a serious question. Is the hearing truly fair? Because a hearing that appears fair on paper is not necessarily fair in reality. There is a concept that must be understood clearly. Participation impairment, it is not a weakness, it is not exaggeration, it is not, it is a recognized legal reality. In most cases it should. When a person has experienced coercive control, financial abuse, a prolonged stress, and their ability to organize and articulate, to respond and to withstand pressure can be significantly affected by just appearing in court. So this is not an opinion, it is the reality that is recognized within both legal and psychological frameworks. And when that impairment is not accounted for, the imbalance grows. Now, let us move into something that is rarely spoken about clearly enough. Domestic abuse. Domestic abuse doesn't always end when a relationship ends. It evolves, it transforms, it continues through process, through litigation, through pressure, through delay, through financial strain, this is what is recognized as post-separation abuse. And if the system does not recognize this transition, it risks becoming an environment in which that abuse continues. That's the system being weaponized by the other side. Because process in itself is not neutral. Process can be used, process can be stretched, process can be weaponized, and not by the system intentionally, but through the way it is navigated. And when one party has greater financial resources, greater familiarity, or greater endurance for prolonged litigation, the balance shifts. And if that shift is not corrected, it becomes entrenched in abuse and tyranny. Now, let's talk about institutional culture. Because systems are not just rules, they are behaviors, they are assumptions, they are patterns, and this is not where the this is where the principle established in the McPherson report becomes crucial, because this happens today. Institutional failure does not require deliberate wrongdoing. It can arise through system, process, culture, cultural norms, unconscious bias, a failure to recognize disadvantage. So when applied to a legal system, this means something very, very serious. It means that a system can produce an unjust outcome without intending to, but the outcome remains unjust. And when that outcome consistently affects those who are vulnerable, particularly women and children in family proceedings, we must be willing to examine it honestly, not emotionally, not defensively, but structurally. There needs to be structure and process, because the consequences are not theoretical, they are real. Loss of housing, loss of finance and financial stability, prolonged litigation, emotional and psychological strain, harm, impact on children, and in some cases, complete destabilization of persons in their life. The whole situations become a trauma. This is why the law exists. The law exists to restrain power, to ensure that one party cannot dominate another through resources, process, or position, to ensure equality of arms, to ensure proportionality, to ensure that the outcome or outcomes are based on evidence and not injurious. But when these principles are not constantly applied, the system begins to drift, and that drift is not harmless. It creates a space, and space for imbalance, space for pressure, space for harm, space for trauma. And that is the point to which we must all be honest about, because when the law is not properly applied, it does not remain neutral. It becomes permissive, it permits, it persists, it permits imbalance to continue, it permits harm to escalate, it permits power to operate without sufficient restraint. And that is the point at which I use the word deliberately, tyranny. Not because the system is designed to be tyrannical, but because the effect in certain conditions reflect that tyranny looks like a modern legal environment. Not chains, not force, but process without protection. Procedure without balance. Authenticity and authorities without accountability. There is no authentic process. Now, let me be clear about something important. This episode does not make any allegations against an individual. It does not name, it does not target, it does not seek to undermine specific proceedings. This is system analysis, because the issue is bigger than any one case. The issue is recurring on revolving doors within family courts. This is why I created Unmasking Justice, not as a reaction, but as a record not as an emotional response, but as a structured examination, not to provoke, but to document. So because if systems are not examined, they do not evolve. A pattern, and if patterns are not identified, they keep repeating themselves. If imbalance is not addressed, it deepens. And so I return to where I began. I will not step back, not because it is easy, but because it is necessary. Because truth, when grounded in evidence and in law, it is not something that can be dismissed indefinitely. There needs to be change. And if you are listening to this and you feel that the system has not fully seen you or fully heard you or fully understood what you are experiencing, then know this: you are not alone in that experience. And more importantly, there is language for it. There is law for it. There are frameworks that recognize it. The challenge is not the absence of law. The challenge is the constance, the content is not being corrected. The procedure is not being applied. The process has been overwhelmed by the court culture, because justice is not a concept. It is meant to be a function. And when that function is not operating correctly, it must be observed, examined, and corrected. So this is not the end of the conversation. This is the beginning of one. A necessary one. A structured one. A lawful one. And I will end this now exactly as I began. I will not step back. I provoke no one. I stand where conscience and duty require. In truth, in spirit, in light. And where the law ends, tyranny begins. And on that note, thank you for listening. And if this episode resonated with you, please share it with someone who needs to hear it. Thank you.